Legal View, where we view the news through the lens of the law.
Good evening, folks. I'm Michael Ayala here with Legal View, and oh boy, we have got a lot to get to tonight. Today, the afternoon in particular, I posted a video earlier about what happened in the morning session. The afternoon session was really all about the state. It was the state's opportunity to put on a case, and they basically got all into even more information that prosecutors had on Carmelo Anthony. And I got to tell you, it raised some serious eyebrows. And again, as I've said many times, I'm not going to fault the defense for what they did. They made a strategic decision in what direction they wanted to go. And I can tell you, it's not the craziest thing in the world, the decision that they made, because there was a lot of really negative information. This was a troubled young man, and he had some struggles. So you know what? Let's just start going through it, because we're going to be together here. I'm going to try to get through it as quick as I can. I know it's late in the evening. I want to try to get through it so we can get a clear understanding of what's happening here. And I'm basically going to go through, I've been following, as I said, the notes of two different stations, WFAA, which is ABC station, and the Fox station out there. In some instances, one is more detailed than the other. In other instances, they're not. So I basically went back and forth, took my own notes as I went through it, and, try to highlight the things that I thought were important. Was a contentious day, if I could call it that. A lot of back and forth between the judge, the attorneys, nothing over the top, but, there were certainly some issues. All right. Again, Judge Michael Chitty was the sitting judge. He was sitting in place of uh, Judge John Roach, who was recused from the case. And so the day began early in the morning. The state was on their case. They started yesterday. Bill Werschke, the prosecutor in the case, was on the stand. He came back to the stand today. And it began with them talking about the agreement. And he was asked about that agreement, and basically he said he thought it was intact after whatever disagreement that they had. If you remember this morning, I was talking about there was some issue as to whether the defense had opened a door by saying Carmelo Anthony played chess in their opening statements. Some back and forth about that. This was during the trial. And ultimately, Toby Shook, as well, when he took the stand, as well as now Bill Werschke, said he thought the agreement was still intact. Now, the judge, again, was in the middle of all this. And as I mentioned earlier, as I said, the judge basically said that, look, I can't do anything about it because it wasn't reduced to writing. And I've been very critical of that. And I don't know why they didn't, but they talk about it a little bit during his testimony. Then they start getting into the information that the prosecution had on Carmelo Anthony. And again, they're bringing this in so that the judge can understand the reason for it, the reasons behind the idea that this deal might have been a good deal for everyone. So let me go through some of these texts, just like I went through the text and the situations that the victim, Austin Metcalf, found himself in. I'm going to go through these as well. And remember, yesterday we talked about the fact that he had had this situation with his girlfriend on the day of the stabbing, where they supposedly had broken up, and it put Carmelo Anthony in a weird state of mind. He sent her a picture with the knife that was actually used in the stabbing, saying, "I'm on the verge." And that's tough to overcome. That's, as I said, nasty stuff. So today we learn a little bit more about what was going on through the mind of Carmelo Anthony. I'll get into a little bit later about whether this would have been admissible. I think some of the stuff we'll talk about here might not have been admissible. There certainly would have been a battle to get them in. So Worski goes through some of these texts. Anthony talks about using weapons, assault rifles. Bill Worski said in a text conversation with his ex-girlfriend, the one who accused him of stalking, Anthony said, I pushed them ends, current parlance, the word ends, the N-word is, so I'll say the N-word. I pushed those N-words to fight me, but they didn't want to. Another text, if you make my face red, like if you can get me mad, I'll turn your face purple. So again, these are threats that he's making to his girlfriend in the time period. Not clear about these time periods, but it sounds like it's in that range in the 2024. This happened in 2025, somewhere in that range. This is all going on. When asked about the deal, Worski said, look, we honored the deal. We gave up a whole bunch, is the way he viewed the deal. And I got to say, I'm not going to dispute that there's a lot here. So let's continue. In another text, his ex-girlfriend appears to tell Anthony to stop his behavior, specifically punching her. And again, this is how it's being characterized. I don't know if the word punching was used in the text, if it was inferred from other texts, I don't know. But this is how it's characterized by Bill Worski as he's giving his testimony about the texts. And so, again, she says, stop punching her. I have to. It's like a priority for me, Anthony wrote. And he wrote something about, hey, we're about ready to fight. And this was in response to a teacher who upset him. Now, these are all text messages. Another text message to his ex-girlfriend. How many bullets you want coming out of your chest? This was from about June 2024. In May of 2024, I'm shooting her. I'm going to beat your butt. I'll use that word. It was a different word. I want you to hit a N-word. I'm going to try to start a fight. 2024, Carmelo Anthony text message. Okay, I'd kill that N-word. October 2024, when I stab SB, I'm going to lick their blood off the table. And he was asked about the text, Bill Worski, and he said, this would be devastating. And I wanted the case to be clean. Again, insinuating that he was helping out Carmelo Anthony by not letting these in. I struggle with that. Because if later on in the trial, when the opportunity comes up for him to tell his story, and you say no, when you know very well, with all your years of experience on both sides, a defense attorney, as well as a prosecutor, that in self-defense cases, the testimony of the defendant is key. So are you really trying to help him? And in my experience with prosecutors are like unicorns. What do prosecutors who want to help defendants and unicorns have in common? They're both figments of your imagination. It's an old joke. But anyway, I just don't buy it, but this is the way he's characterizing it. He said at one point he second-guessed his decision to accept the agreement. He says his own trial team disagreed about wanting this evidence out. Worski said he had to balance both sides. They continue to go on over the text after that. He says, I will kill, this is Anthony in his texts, I will kill his butt, another word again, I will murder that N-word. Worski keeps saying all of these things he would have introduced during the trial, and it would have been death by 1,000 cuts. And I can't disagree with him. If I'm a defense attorney representing Carmelo Anthony, and this stuff is out there, it's problematic. And the only argument I could make is that when we see Austin Metcalf stuff, he had stuff that was really happening. He was bullying people. He was hitting people. It was happening in real life. This is all text messages. And that's not to excuse the ugliness of the text messages. When you put them together, it seems terrible. There are time frames here. So there might be a text in 1 month, June, then there was another text in May, then a couple in October. So it's happening over a time span. Something might have upset him. So I would have emphasized these things to the jury, that these are text messages. These aren't things that are really happening. But just as a father, as a human being, He seems like a troubled young man. These are not thoughts you want your son having. And he's obviously struggling with something. He probably needed to talk to someone. But again, this doesn't seem to be happening in real life, any of this real serious violence that he's talking about. In November of 2024, actually, there's an incident report where Anthony took a gun and a knife to school. Saw the same gun situation with Austin Metcalf, fascination with guns. Austin Metcalf made threats with guns. Doesn't say here that Carmelo Anthony made any threats with guns, but he got caught with a gun and a knife at school. Not good. And so the way Bill Worski characterized it, he said, when put all together and then you know how the story ends, which is with the stabbing of Austin Metcalf, he says these text messages take on a different meaning. And I can't argue with him. Again, I would try to undercut some of that argument, but he does seem like a troubled young man who was on a crash course to something really bad happening. You know, and I know, you are what you think. You are what you do. And if this is the kind of stuff he's thinking, it's only a matter of time before he acts out on it. Was it that day? I don't know, but that's certainly how prosecutors would have wanted to make it seem. And it wouldn't have been that hard with this stuff. There's more text. He texts his girlfriend, I want to effing kill you. B word. He wants to stick that rifle in your mouth and claim PTSD. There's other texts. They didn't go specifically into them, but apparently Bill Worski said there were texts about drug talk, robbing people, physical violence. There's actually a video of Carmelo Anthony driving by a house and pointing a gun. Although it's a still image, I didn't personally see it, but the reporter reporting on it says you really can't 100% tell what exactly is going on in the picture, but that's how it was characterized by prosecutor Bill Worski. I want to talk about this, whether this could get into evidence. There's a question as to what could come in. Character evidence or evidence brought in like this to show that he's a violent kid and therefore it proves that he acted violently on that day. Or he had a penchant for violence, so he had a penchant for violence. That's character evidence. That's not allowed. But it can show within a context a state of mind. That's an exception. Prosecutors would have said all of these texts work together to suggest this was the state of mind of Carmelo Anthony. You put that in with the text and the situation with his girlfriend on the day of the stabbing. I think it's a pretty good argument that a lot of these texts within that time frame, 2024, perhaps as far as 2023, would have been allowed in to suggest the frame of mind of Carmelo Anthony, which makes it a very, very difficult case for him. There's more text messages. There's racist language towards Black people. That's the way he characterized it. It's not how I see it. I'm not sure that's how Black people would see this. He says, I effing despise Black B words. All the wig glue get into their brains. Them effing N's, N words need to die. These are ugly, ugly thoughts. I don't characterize those as racist thoughts, but I'm not going to argue about that with you right now. I think Black people who are watching this will understand what I mean, but it's ugly and it's not good. And it's something that's endemic in the Black community, but I'm not going to go there right now. Worski said he knew that there could be that sudden passion argument, something that the prosecution was angling for, and that jurors might be able to consider lesser offenses. And we heard Toby Shook testify earlier today that he thought that he could get a manslaughter by putting Carmelo on the stand. So it's clear that that's what the defense was going for. So he knew what was coming. That's what Bill Worski says. Now, it's important that we understand that there are limits to the type of evidence that could be brought in, and I touched on it a little earlier. But here, they talked about some evidence that I think they would have struggled to get in. They talk about disciplinary records in school. This is from a Baton Rouge school when Anthony was 6 or 7 years old. He was punching another student and had willful disobedience. He was on a behavioral plan through a Louisiana State University psych program. At age 10, there were multiple reports that Anthony was having fights with students and willful disobedience in the classroom. This is the type of evidence that I believe the state would have struggled to get in. We're talking about stuff when he was 6 and 7 years old. Very far removed. As a defense attorney, you would argue this is piling on. It's far removed from when he's 17, which is when this incident took place. And the rules of evidence in Texas, I think, would not have allowed this in. But here's what Bill Worski said. He said, when asked about this evidence, he said, we know how to use this evidence. So he would have found some way to get that evidence in front of the jury. This goes back to an article I wrote a few weeks ago about the power of prosecutors, the ability to manipulate things, to get things the way they want, especially if you have a judge who's sort of not in cahoots, but has a prosecutorial state of mind. They're all working towards a conclusion. And yes, prosecutors can get this in. But legally, it would be extremely problematic because even if you present this evidence, there's a balancing test that a judge has to do. And again, now you put the discretion into the judge's hands. And he has to look at the probative value. What does this prove versus how prejudicial it is? And I would argue very strenuously that this doesn't really prove very much about what he does at 17 on that day with Austin Metcalf. I think I could pull disciplinary records from my youth, my son's youth, where there will be disobedience. There may be some fighting. But also, I had done an interview a while back with Dr. Sonny Slaughter. And we talked about, before we knew the specifics of these disciplinary records, we talked about she needed to know more. This is the more she was talking about. She needed to know how old he was. She needed to know what type of infractions there were. She needed to know if he was on a special plan. And he might have had issues with ADHD that were undiagnosed. He might have had other issues. It looks like he was on some sort of psych plan with the Louisiana State University. So clearly, maybe there was something going on there. No specifics on that. But this is exactly what she was talking about. You need to know more about what was going on with Carmelo Anthony. I can tell you, I did a documentary series where we worked within the juvenile justice system. And the folks who I talked to who worked within the system, and this was in New York City, said that 70 to 80% of those kids have learning disabilities of some sort. Anything from ADHD to dyslexia. And sitting in those school environments was very difficult for them. And they all had lengthy disciplinary records, disobedience, acting out. A lot of that has to do with your ability to concentrate and work within the confines of a classroom. So I would have made all these arguments in court, hopefully kept that stuff out. Again, I don't think this stuff is really probative of anything. He goes on to talk about some text messages. I believe this goes back to about 2023, where Anthony hit a girl in the face. And the way Bilworski characterized it, the way he would have put all these together, is Carmelo Anthony seemed to have an obsession with fighting when he searched the phone. So again, all these things work together and create really a terrible picture. But what you see is all text. So in assessing this evidence as a defense attorney, whether I want to bring this in, I think there's a strong argument for you to make that I could argue that these are all the rants of a kid who's struggling with some anger issues, but none of this is really happening outside of his text messages. He's expressing himself to his girlfriend, treating her very poorly. It's unfortunate, that's what's going on. I feel like I don't know how much his parents knew of what was going on in his mind, his obsession with violence, his anger, his treatment of girls. But I think it's clear that Carmelo Anthony needed help. He needed to work through these things. But as we look at and begin to apply it to the situation on that day, I'm still struggling with the idea that what we're seeing here means that he got up that day or went to that tent to kill someone. And here's why. He goes over to that tent because his friend, and I use that air quotes, calls him over. And he's sitting there for a few minutes before he's being told to leave, and then he gets belligerent. And before these four boys, Austin Metcalf, two other guys, and Hunter Metcalf show up, there are kids that are challenging his presence under the tent. If he really was there that day and his whole mindset was, I wanted to kill someone, why not create that situation right then and there with the kids who are alone, the kids who are more his size? But instead, he waits till he's surrounded by four guys, at least two of them 150 pounds more than him, weighing more than him, almost twice his size. He was 130 pounds. These kids were in the 200s, mid 200s. Why wait till then to decide, okay, this is the guy I'm going to kill? So if I'm deliberating with other folks and we're talking about this, this is the way I would talk about it. I'm not buying this idea that he was just at the tent trying to find someone to kill. But now as a defense attorney, I got to find ways to get in this stuff about Austin Metcalf. And there's part of the law in Texas is if there's an issue as to who the aggressor was, you can get in evidence about the victim. And I try to work through that. There would have been a string of hearings where this could have been worked out. And I submit to you that if this was really about Carmelo Anthony and his ability to get a fair trial, I'm a prosecutor. I want this stuff on the record. I want to litigate this stuff in motions. I want to see what I can win. What can I get in? What can the defense get in? And then I will say, maybe at that point, we're all in a better position to decide there should be some sort of agreement. But before it all happens, the prosecutor is making a determination. And this is part of what I talked about earlier, the power of the prosecutor. He, on his own, decides a fair trial for Carmelo Anthony means we don't get the backgrounds of both of these guys in. That's a clean trial to him. He's making that decision. And I know people have come back at me, social media. Well, the defense was there and they agreed to it. And they did. And they did. And that's problematic. That's probably going to be the biggest problem for this appeal all along the line. Because when they had the opportunity to object, they didn't. And they made a strategic decision to allow this evidence in, to keep this evidence out. And so it's hard. It's difficult. Again, these are low percentage things. Now, Russell Wilson went up on cross-examination and he asked him about this deal and said, why didn't you put this deal in writing? Bill Werschke responds, it would have been a fool's errand because the agreement's very nuanced. The whole agreement was premised on truth and trust. And I get it. I agree. There were so many little nuances as to what you could and couldn't do, what would have and wouldn't have opened the door, who could testify to what questions could you ask. To try to put that in writing would have been difficult. Which for me, as a defense attorney, is why I would have wanted to go a different route. Because I'll go back to the old joke. What do prosecutors who want to help defendants unicorns, and agreements that aren't put to paper have in common. They're all figments of your imagination. And that's exactly what happened here. Whatever agreement each one of them believed they had, it was a figment of their imagination. Bilwerski thought it included not Carmelo not testifying. The defense thought it meant Carmelo would testify. It was all a figment of their imagination. So as a defense attorney, I can't go forward that way. Maybe Toby Shook told Mike Howard, hey, I know him, I trust him, and this is how we're going to go about it. Excuse me. Mike Howard might have deferred to that. I don't know. There's no testimony to that effect. But it went awry. Now, Russell Wilson continues on. And he asks him, have you ever done these agreements before? And he said, yes. And he said, had it ever gone sideways? And he said, no. This is the first time. So again, these prosecutors are functioning in this manner. They're looking at these cases and they're wielding their power to steer them whichever way they want to steer them. I can't see it any other way when you go to the defense and say, let's keep it a clean trial. Let's not have any of this information about either side in. The only way I can characterize it as far as the prosecutor is concerned is that they were worried about how this might turn out if the information about Metcalf was allowed in. Because while they had a lot of really ugly things in those text messages, there wasn't anything really physical. He did a lot of talking, but he wasn't an actor. He didn't go out and do a whole lot of physical violence to people. And his girlfriend was going to come in and testify to undercut what I thought was probably the worst evidence for the prosecution, which was she thought he was stalking her and he sent her that really ugly text message on the day of the killing. So what he was looking at was possibly a conviction of less than murder and maybe manslaughter. If Carmelo testifies, all this comes in. So that's what I think his head was at. And you saw what he testified to on direct. He said he knew they were going to be angling for something less by using that sudden passion, which would have reduced it to manslaughter. And so, again, I'm not buying that this was all about Carmelo and helping him out. And he did say it was for both sides. Okay. Now, the other little thing I want to talk about is the decision that was made to close the courtroom. This was done because the prosecutor felt he needed to keep everyone safe. And in conjunction with the judge, they decided that they were going to keep this shadow docket. None of this stuff was going to be made public. And this was the way that he was going to keep people safe. Look, that's all well and good. It's fine. But again, I want to point to the power of the prosecutor. Nothing he did there was illegal. The agreement that we heard about between the Collin County judges that we're not going to have cameras in Collin County, it's not illegal. I mean, well, you could argue if you have a statute that says cameras are allowed and you decide with an informal agreement that they're not going to be allowed in the courtroom, well, maybe it is, maybe it's not. But these are decisions, as I mentioned yesterday, that are being made by folks on their own. Who is Bill Werschke to decide how to keep everybody safe? The proper way to go about it would have been to have a hearing, talk about your concerns. And he talked about trials where there had been serious threats, bomb threats. There had been serious threats in this case. And he was concerned about the information getting out about Austin Metcalf and Carmelo Anthony, getting out into the public and causing a stir. What was he afraid of? The black community? The white community? Who was he afraid of? You tell me. But the proper way to do this would have been to have a hearing and say, we have these concerns. Let's get this on the record. I've got threats. I've got this. I've got that. And then the other side could say, well, this, that, and the other thing. Here's what we think is best. All sides agree on the record, and then we move forward. Now, that did happen in a way because the defense knew about the propositions that were being made by the prosecutor, and they agreed to them. And it's problematic. They agreed to all of this. They agreed to the deal, and they agreed to this keeping people out of the trial, not having the closed circuit. And moving ahead to closing arguments, the prosecutor, who was representing the state in this instance, his main argument in closings was, Judge, you shouldn't even be considering this because the defense agreed to all the restrictions that we had. And in fact, the restrictions aren't really as being portrayed by the defense because even though we didn't have the closed circuit in the other courtroom so that people could be in the overflow room, we tried our best to fit as many people as we could in the courtroom. Sure, it was inconvenient. There were long lines, but we did the best we could to have the public in. We didn't technically keep the public out completely. And I think he's right on both counts. They did what they could as far as allowing people in, the public. And whatever restrictions they decided on early on because of wanting to keep people safe, the defense agreed to. You run into the same problem with the agreement. Michael Chitty, who's going to be determining this, is going to look at that and say, they agreed to this. And while there was this misunderstanding, my hands are just as tied as the original judge because it's an unenforceable agreement because it wasn't reduced to writing. It's a figment of the imagination of both sides, and they imagined it differently. So this is not going to, I think this is not going to end well. Not a surprise, because these are difficult. Now, there was some difficult to win. There was some question as to whether Judge Chitty would rule today. He said no, he's going to take it under advisement throughout the weekend. As I said, Monday is that deadline. So whatever ruling he has will come on Monday. And that's where we're at. That's where we're at. And just in closing, let me say, what I see here, unfortunately, is two troubled kids. I don't think you can deny Carmelo Anthony was struggling with something. Clearly, with the issues that Metcalf had, he was struggling with something. These were two kids that were struggling with, anger issues, whatever other issues. And they were on a collision course. And it's unfortunate that they met that day because I'm not 100% sure that if Austin Metcalf heeds the warning that was given to him by Carmelo Anthony, and he says, don't touch me, you'll see what happens. If he just says, hey, whatever, and doesn't put his hands on him, that anybody gets stabbed that day. This is not saying Carmelo Anthony's not guilty of a crime. What I'm saying is these two kids were on a collision course, and the issues that they're dealing with put them in a position where Austin Metcalf felt it was his duty to push him, and Carmelo Anthony decided that he was going to do what he did, pull out a knife and swing it and stab Austin Metcalf. And if not that situation, either one of them were going to end up in a situation that probably wasn't going to end very well. They would end up either in prison or in some other situation because they had issues they weren't dealing with. It's unfortunate. It makes me sad. It makes me sad. That's what happened in the evening. Just incredible. A lot of information coming out. All of it makes you sad. All of it makes you see what a tragedy this really is. We'll see what Judge Chitty does. We'll be back on Monday when he makes his decision. We'll go through that decision. I would imagine you're going to see something where he's denying the motion for a new trial, talking about that there were the Waller, the precedent where you have to have reasons on the record, and when you decide to have to keep the public out of a trial. He's going to say, look, the public really technically wasn't kept out of the trial, and whatever was done was agreed to. Whatever restrictions were there were agreed to by the defense, so there's nothing much you can do. Same thing with the agreement. The agreement was made and agreed to by the defense, and unfortunately, it's just not enforceable. Their interpretation of it is not enforceable. And as I said before, it still doesn't mean Carmelo Anthony got a fair trial. I think a lot of us look at this and feel like this deal, this whole thing, the secretive nature of it, the backroom deal, the gentleman's agreements, this stuff has to stop. When we're talking about things as serious as this, I don't know if the main thing on the prosecutor's mind when he went to make this deal was making sure Carmelo Anthony got a fair trial. Because it doesn't match up when you say whatever you were thinking doesn't coincide with him testifying. In a self-defense case, it just doesn't match up. So I can't buy that. But that's it for today, folks. Truly appreciate you being with me here on Legal View. It's been a pleasure bringing this information to you. I hope you've enjoyed it. Continue to check back, like, and subscribe, please. It really helps out a lot. I want to continue to grow. I'll keep bringing you this stuff as well. So again, thank you so much. And folks, have a wonderful, wonderful.
This is Legal View, where we look at the news from a legal point of view.